Hi, I'm Jim Covington on behalf of the Illinois State Bar Association. Today is September 29th, 2011. For this week's issue of ISBA Statehouse Review. I have three bills we want to talk about with you in the context of veto session, which will be 3 days in mid-October and 3 days in mid-November. The first one is a public act, but I wanted to reiterate about it because it's in effect, took effect on July 14th, and it affects your power of attorneys and the statutory forms, and it is Public Act 97-148, which you can get a clean copy of on the General Assembly's excellent website, which is www.ilga.gov. And in the big rewrite of the Power of Attorney Act that took effect in July 1 of this year, that was drafted a year ago, they put into the healthcare power of attorney the ability of the principal to get the medical records of the agent springing ahead. You know, they could get them immediately. It's sprang to life, if I'm using the right verb there. The medical providers and the hospital associations got a little nervous about that and went in and asked the General Assembly to revert that back to prior law, which is that it only takes effect getting the access to the medical records by the principal of the agent. It only takes effect on a designated event or time that the agent so designates in the healthcare power of attorney in the statutory short form. The second bill that I want to talk to you about, it will be heard in veto session, I believe, and it is House Bill 1589, sponsored by Representative Bob Pritchard in DeKalb. And this is going to amend the, if passed by the Senate, and it's passed the House already, is going to amend the Illinois Marriage and Dissolution of Marriage Act about modification of custody orders and visitation orders. It's an initiative of the USA Families, which is a part of the Department of Defense. What the USA Families were trying to do across the country is sort of make uniform modification orders because there's been so many deployments and so many of these folks are single parents. And this bill essentially does 5 things. And it first sort of expands existing law to address modification of custody and visitation orders for deployed service personnel. The second thing it does is it preserves judicial discretion for the best interest of the child. That's still the prime directive, as Captain James T. Kirk would say. The third thing it does is limits modification orders for deployment to temporary status, so no deployed parent has to come home and is faced with a clear and convincing burden to restore a prior order that was changed solely because his or her deployment. The fourth thing it does is it expedites custody hearings, and it allows the service members to participate by electronic means. I think that's probably within the purview of the court's discretion to already allow, but they wanted to codify that. The fifth and final thing it does is it allows, quote, substitution visitation, close quote, by people who are close to the child or children if it's in the best interest of the child in the discretion of the judge. And when a deployed service member goes overseas, there may be an uncle, a brother, a sister, father, mother, or somebody that will help bridge that deployment in terms with the child, and they wanted to recognize that statutorily. And anyway, that will be heard in the Senate, and I think Representative Pritchard wants to try to move that in the fall veto session. Our thanks to Rory Weiler in Illinois of the Family Law Section Council, who sat down with the USA Families on the telephone and worked that out. The third and final bill that I want to talk about is House Bill 1712, and that has been amendatorily vetoed by Governor Quinn, so the General Assembly can either accept that veto, do nothing and the bill dies, or override the veto. I don't know what the proponents will do with this bill. Last year, when the General Assembly rewrote the Power of Attorney Act with a big emphasis on trying to protect seniors and vulnerable disabled folks, the part of that bill has triggered a reaction by some of the larger corporate banks because they have a lot of limited power of attorneys which are solely for business transactions. They're nothing to do with protecting adults or anything like that. They found the act a little bit oppressive for those certain limited kinds of powers of attorneys for limited financial or business reasons between and among corporate entities. And so they went in and asked the General Assembly, which it did, passed a bill to basically do 2 things: create categories of excluded powers of attorney where all the Act's protections and responsibilities didn't quite apply, and then remove some of the agent's responsibilities for those limited business agreements. Governor Quinn thought that had no real problem in his mandatory veto message with what the corporate banks were trying to do. He understood that, but he thought that they inadvertently might, the law that's changed might inadvertently in some way hurt some vulnerable seniors. So he went in and essentially trimmed it back a little, if I can paraphrase, and did about 4 things to that. And the first thing was he trimmed back from 14 to 11 the categories that are listed in the bill of what is an excluded power of attorney. He clarified to make certain how revocation of prior powers of attorneys was accomplished, and then he put back in the responsibilities and the duties of agents that were excluded for these limited powers of attorney. And the fourth and final thing he did is he limited the revocation to the statutory power of attorney short form. And if I recall correctly, trying to mimic how wills and other estate planning documents were done, in the statutory short form it puts in there, I hereby revocate any prior powers of attorney. I think he's limited that to the statutory short form for property, which probably doesn't affect the corporate interest in their limited powers of attorney, so that probably works out for all concerned, I think. Anyway, we will see you next week, and have a nice day.